So thank you all for coming. Today we have Justice Glen MacDougall with us. Glen and I are hockey buddies, so our relationship is a little bit more informal. So he might make jokes at my expense throughout. Don't laugh. But he's here to talk about the law, being a judge, being a lawyer, etc. So if any of you have any interest in pursuing a career in law, for example, this is a perfect opportunity to talk to somebody who has a ton of experience. Okay? So we'll let Glen take over, and at the end we'll take some questions. We have about an hour because I need about 15 minutes at the end.
Sounds great.
All right.
Okay, well, thank you very much, Ashley, and thank you for not skipping class today. You obviously didn't tell them I was going to be here. As Ashley mentioned, he and I are hockey buddies, and it's great playing on a line with Ashley. He knows where I park myself, just off to the side of the net, and every once in a while he'll bank one in off my shin pad so I can go home and brag about my scoring prowess. That's about the only way I can score goals these days. I do have, I guess, a connection to St. Mary's in that I'm a graduate of St. Mary's. Way back when the Jesuits weren't here then, but was shortly after I think they departed. My wife has 2 degrees from St. Mary's, and 3 of our 4 children are all graduates of St. Mary's. So this building probably was financed out of my pocket. So hopefully you're enjoying the environment. The other thing I guess I'd like to encourage you, if you have any questions at all, please. This is your opportunity. You probably don't get a chance very often to meet face-to-face with a judge, and I know probably it's a little bit intimidating. It's intimidating for me to be here in front of so many different sets of eyes, but this is a chance for you to ask questions, and if you do ask questions, it gives me an idea of what you are interested in. I'm assuming some of you are interested maybe in pursuing the profession of law or policing or something involved with the administration of justice, either as security people at correctional institutions or just not just, but criminologists as well. But like I said, if you do have any questions that you think I can answer, I'll be happy to hear from you. Ashley had mentioned that I had been a judge and obviously a lawyer before then. I was a practicing lawyer in Sydney for about 18 years. I'm originally from Cape Breton, and if I hadn't gotten seasick all the time when I was a kid, I probably would be a lobster fisherman or close to retirement as a lobster fisherman now. But in any event, I practiced law in Sydney for over 18 years, and a little over 15 years ago I was appointed to the Supreme Court, which required a transfer of my wife and I and several members of our family. I think it was an opportune time in that our 2 older children were at university, and they decided to transfer from where they had started university to St. Mary's so that they could share my apartment, which after about 2 months was their apartment that I was sharing with them. I was simply paying the bills, but that's another story. The other 2 were in grade 12 and grade 11 respectively, so they were getting to the point where they were about to move on to university. As I said, one of them, my son, went to St. Mary's. And our youngest daughter, she kind of broke the mold and decided to go to Dell from the get-go instead of going to St. Mary's. I kind of joke with her that she made life more difficult for me because instead of just redirecting my monthly paycheck to the bursar at St. Mary's, I had to write a separate check to cover her fees at Dell as well. Anyway, so our family has a close connection to St. Mary's, and I guess I have one other connection with your class. I'm not sure if Katie is going to appreciate me pointing out the fact that her much older brother, Mike, is married to my daughter, Ainsley.
That doesn't give you an automatic
No. This might. They're expecting their first child, which is our first grandchild. Make it emotional. Sorry. Anyway, that'll be a special time. You'll see I brought some props with me. Criminal Code, obviously, that's sort of my Bible. And if you're interested in looking at the pictures of old judges, not surprisingly, mostly male judges, here's a book that one of my colleagues, retired Justice Charlie Halliburton, authored a couple of years back. But it was done in, I guess, to commemorate the 250th anniversary of the Supreme Court of Nova Scotia. The Supreme Court of Nova Scotia is the first, obviously the oldest then, Supreme Court in the country. And the very first Chief Justice was this gentleman who graces the cover of the book, Sir Jonathan Belcher, I think, originally from Ireland, and had been practicing law in I guess it was before the United States for the United States, but in what is now the United States, and he was enticed to come to Halifax to be the very first Chief Justice. Since he was the only judge of the court, not difficult then to aspire to be the Chief Justice as well. But there are photographs and write-ups of all of the judges in the Supreme Court, some of the county court judges as well, and there's even a picture of me when I had less gray and more hair a few years back. I've been on the bench for 15 years, and when you're appointed to the Supreme Court or the Court of Appeal, the federal government appoints you. And you can stay as a judge as long as your health will allow and as long as you don't get removed for making some kind of an egregious error until you're 75. At one time, like senators, when judges were appointed to a superior court, you could stay for life. They still have that in the U.S. The U.S. Supreme Court justices, they have no requirement to retire. They can stay in office until, I guess, the day that they pass on. But I'm not sure if that's a good thing or not, quite frankly, because I think we all reach a best before date. And if you're there for, in my case, it will have been 27 years, I guess, maximum that I could be on the bench. It's about time I moved on and allow somebody else to take the position. Anyway, I'm going to talk a little bit about the composition of the courts, and there's one thing, if you are interested in the history of our court and all the courts, I guess, in Nova Scotia, there is a website, or you can just I guess Google Nova Scotia courts, and it'll take you to www.courts.ns.ca, and there is a wealth of information there, not simply on the history of the courts, but it'll give you information with regard to the type of cases that go before the different courts. If you are involved in some kind of a court matter, either criminal or civil, then it will give you information on how you can represent yourself and what some of the procedural steps that you'll have to take are. As I said, it's for anybody who is interested, it is an excellent website. I think it's probably rated the top courts website in the entire country. We have had some very good people design it and to keep it updated as well. So I would encourage you to look into that. I mentioned that I'm on the Supreme Court. The Supreme Court is the superior court of criminal jurisdiction in Nova Scotia. In other words, all of the serious criminal matters would come before our court, and they involve the cases where there are allegations of murder, either first degree or second degree murder, or the sexual assaults, robberies, all of the more serious indictable offenses that are listed in the criminal code would eventually find their way to our court. Some serious offenses are what are called hybrid offenses. The Crown prosecutor can decide if he or she is going to prosecute by way of indictment, which again then gives the accused the option to elect trial either in provincial court, Supreme Court, judge alone, or Supreme Court with a judge and jury. Sometimes there's no option. Murder charges automatically go to our court to be tried by a judge and jury. However, if the accused decides he or she wants to be heard or have his trial heard her trial heard by a judge alone. They can elect to be tried by a judge alone, but the Crown Prosecutor has to consent to it. Normally, it would be done by a judge and jury. The other matters that I would deal with in the Supreme Court are civil matters. Most of our docket, quite frankly, involves cases where individuals are suing other individuals, or there may be individuals and corporate parties involved, or individuals or corporate parties suing government or vice versa. Those types of civil trials take up about, I would think, 2/3 of the docket. What I've been doing for the past 5 months now, I've been specializing in chambers matters, and I'll explain a little bit more about that later. And I'm doing all bankruptcy and insolvency matters, and I also do CCAA matters, which are Corporate Creditors Arrangement Act matters. In other words, it's for individuals or companies who are experiencing financial insolvency, or in some cases bankruptcy, and they have to, someone has to apply to the court to have a receiver appointed, or maybe it's an individual who has made a voluntary assignment in bankruptcy because they can't meet their debt load. Then I have to deal with those matters as well, which normally come before me on Friday afternoon, and I could deal with anywhere from between 30 and 40 of these motions for discharge, either on conditions or absolute discharges, if the debtor has fulfilled all his or her conditions and have taken counseling lessons, pardon me, and have, as best they can, liquidated their assets to pay off their debts. Usually there's not near enough money or near enough assets to liquidate to pay off all the debts. And we sometimes have people who are in for the second, third. 2 weeks ago I had somebody in for the fourth time, and then you have to wonder whether or not somebody is just gaming the system. Are they just racking up all these debts and then taking the easy way out? They can try that, but if they do, and it's obvious that they are doing it, then their discharge from bankruptcy is suspended for, in some cases, 3-4 years. So it prevents them, I guess, from going out and doing the same thing for a fifth or sixth time, as the case may be. So far, a fourth time bankrupt has won the, I guess, the award in my court. The other I guess, courts in the province, and there are numerous courts in the province. I'd mentioned to you about our court, the Supreme Court. The Supreme Court, by the way, in some provinces, such as New Brunswick and in Alberta, for instance, it's called the Court of Queen's Bench, not the Supreme Court, which ours is the Supreme Court of Nova Scotia. Ontario, the Superior Court is called the Ontario High Court of Justice. And in Quebec, I can't pronounce it very well in French. It's the Cour Supérieure, so Superior Court. In our province, the very top court is the Nova Scotia Court of Appeal. At one time, not that many years ago, the Supreme Court of Nova Scotia had two divisions, the Appeal Division and the Trial Division. But in 1992, I think it was, they decided that it would be better to create a separate Court of Appeal. They happen to be in the same building where my office is, but they are a separate court. Their Chief Justice, Michael MacDougall, is not only Chief Justice of the Court of Appeal, he's the Chief Justice of the province of Nova Scotia. We have a Chief Justice too, Joseph Kennedy, who holds an honorary doctorate and graduated from St. Mary's a few years before I did, but anyway, he has a very, very close affiliation with St. Mary's as well. So he is our Chief Justice, Joseph Kennedy, and we have two Associate Chief Justices because we have two divisions in the Supreme Court. One is the General Division, of which I am a member, and I do mostly criminal and civil matters. And then there's a Family Division, and they do all matters pertaining to divorce, separation, they do child custody, everything that's involved with a couple who have decided to go their separate ways. But the Family Division only sits in HRM, so they cover all of Halifax County and Cape Breton Island. When the federal government back in 1997 decided to create a family division of the Supreme Court, they were prepared to put so much money into it to see how it would work. But they didn't spread it out across the entire province, which is what they should do, but they haven't. So when I go out on circuit, which I often do, I could sit in Yarmouth, I could sit in Amherst, I could sit in Sydney or whatever, but anywhere in mainland Nova Scotia, outside of HRM, I do a lot of family law. So divorces, we don't do child protection. That's done by a family court judge who is appointed provincially. That's another level of court altogether. So again, the very top level of court in the province is the Nova Scotia Court of Appeal with its own Chief Justice, our court, the Supreme Court of Nova Scotia, with our Chief Justice and 2 Associate Chief Justices, and then the court below us is the Provincial Court. And most times when you're hearing about matters in the press, they involve what's going on in the Provincial Court. Judges of our court, judges of the Court of Appeal are all appointed by the federal government. Judges in the Provincial Court and the Family Court, because there's a Provincial Family Court, they're appointed by the government of the province of Nova Scotia. If you are a provincial court judge, you deal probably 95% of your work would be criminal. It could be doing trials of summary conviction offenses, or you could be doing preliminary inquiries. So if someone is charged with first or second degree murder or whatever, they go to the provincial court first. Yesterday there was a lot of coverage on a gentleman who is alleged to have shot and killed somebody over the weekend. That was provincial court. The reason it goes to provincial court is to set a date, first for a bail hearing, and secondly, a date for a preliminary inquiry. The preliminary inquiry is sort of like a mini trial, I suppose, where the Crown has to present its evidence, and the judge who is presiding over the preliminary inquiry has to decide if there is sufficient evidence that if a jury was properly instructed, there's sufficient evidence that could result in a conviction. Once that determination is made, that matter gets moved to our court, and then we set dates for the actual trial. And again, with the serious ones, it's usually a trial before a judge and jury. And I'll probably speak a little bit later to you about the jury trial procedures and what's involved there in terms of selecting a jury normally of 12, but it could be upwards of 14 people, and you could have alternates besides that. But we'll talk about that later, as long as we have enough time. So the other courts in Nova Scotia, besides the Provincial and Family Court, the Supreme Court, General and Family Division, and the Nova Scotia Court of Appeal, there are courts, and I had referred to this earlier, in bankruptcy, which a Supreme Court judge sits as a judge in a court of bankruptcy. There's a court of probate. Normally, most matters are dealt with by the registrar of probate. This is for wills and estates and things of that nature. But there are matters that have to be decided by a judge sitting as a judge of the court of probate. And again, Supreme Court judges, we put that hat on occasion when required. Sometimes people will go to the court of probate to decide if what purports to be the last will and testament of somebody is a valid will. Should it be proved as a will, so that the personal representative named in the will can then take over the estate assets, gather them in, pay off all just debts, and then distribute what's left over in accordance with the instructions in the will. Sometimes people challenge those wills. They say that it's not the last will, there is a later will, or secondly, the testator or testatrix, if it's a female, when giving instructions for the will, did not have competence. They did not understand what they were doing, and the will should not be therefore validated. Or sometimes the allegation is that somebody coerced. They put pressure on somebody to, distribute their assets after their death in a way that the person would not have done on his or her own, but they basically gave in to pressure from somebody else, either family member, or whoever. So those are the kinds of things that I would have to deal with if someone wanted to approve a will in solemn form. I have one of those tomorrow, as a matter of fact. And the reason it's on my docket tomorrow is not because someone's alleging that the testatrix, in this case it is a lady, was incompetent, or that she was coerced into, I guess, drafting the will or giving instructions for a will the way she did. The problem is no one can find the original of the will. They have a copy of it, signed, witnessed. They have an addendum called a codicil referring back to this will, so what the estate lawyer wants me to do is to look at this to determine if the copy of the will can be entered into probate. And notices have to be given to anybody who may be affected by it. An advertisement has to be placed in what's called the Royal Gazette, so that anybody who may be affected by the ruling that I'm being asked to make can attend, and if they have an objection to it, then I won't hear it. I'll set it over because it's going to take far, far too long. Tomorrow on my chambers docket, and I start at 9:30 tomorrow morning, I've got 22 separate matters to deal with, plus I have a special at 11 o'clock. I'm lucky if I get to my special by 1 o'clock in the afternoon, quite frankly, tomorrow. It's an impossible docket. It should not have been allowed to grow that large, but by the time anybody realized how large it was kind of late to change it, because a lot of these things, people have to give notice to other parties or other people who may be affected. To maybe just change it by a day or two means people will come in and have wasted their time coming in and be asked to come back. So anyway, I'm stuck with it. I'll make the best of it.
What is a special?
Special chambers, anything that takes a half an hour or less would be on regular chambers. But if you anticipate it's going to take half a day or less, then you can get a special time at 11 o'clock on a Tuesday, Wednesday, or Thursday, or you can get one at 2 o'clock in the afternoon on those 3 days. Other chambers matters, and it's usually to deal not with originating things, but sometimes they are originating applications, but they're usually motions. And if it's felt that the application or the motion is going to take like a full day, then another complex chambers date is assigned, where it would start at 9:30 in the morning and go. Sometimes these complex chambers matters, they're really I find them very, very complicated. They're very difficult, and some of them can go 2 or 3 days. It's especially like if it's a summary judgment motion, for instance. Again, this is in civil law, and I'm kind of bouncing around here, and I apologize for that. But if it's a motion for summary judgment, that means someone who is suing someone else, the plaintiff, he or she is called, if they decide or I guess if not they decide, if they believe that the other side's defense is not a viable defense, they can bring a summary judgment motion to strike the defense so that they can then go and get default judgment in effect. Obviously, that's determinative of the entire matter, isn't it? The entire action. On the other hand, a defendant may bring a motion for summary judgment, and there's two types of summary judgments too. One is on evidence, and the other one's on pleadings. But I don't think we have to get into the intricacies of the civil procedure rules, at least not to that degree. But the defendant may advance a motion to say, look, the plaintiff doesn't have a case here. They're just based on their pleadings, based on the evidence, they cannot make out a claim that's valid, and we should not be forced to go through the time, the expense of defending it. Throw the thing out before it wastes any more time and money. And as you can well imagine, because the result of those motions could decide whether or not the thing goes forward or not. A lot of time and effort is put into it. And because of that, they can become quite quite complex and quite difficult to decide, quite frankly. So again, general chambers, if it's felt to be a half an hour or less. Now, for instance, tomorrow where I have 21 matters on, if they all took a half an hour, I'm going to be in chambers for quite some time tomorrow. But a lot of the work that I do on Wednesday, Thursday, and Friday mornings when I do chambers, it's foreclosure matters. People looking for an order for foreclosure, sale, and possession. People have been unable to make their mortgage payments. They probably just gave the keys back to the bank and have left. So the motion is to get the order to allow for a public auction to take place to see if they can sell it. Oftentimes what I find is the banks are buying in at the public auction, and eventually they will find a buyer, and if they can find a buyer and still are owed money, then I see them back in 6 months' time on a motion for a deficiency. I've seen cases where people have mortgaged their property for $75,000, for instance. They pay on the mortgage for a couple of years. They can't continue the payments. The bank forecloses. They get their order for foreclosure, sale, and possession. They sell it at the public auction. And at the end of the day, the bank comes back looking for a deficiency, and the deficiency could be almost as much as the original mortgage. So the parties, the mortgagors, the borrowers, not only have lost their property, but they're still on the hook for probably just every penny that they borrowed in the first instance, which seems unfair. But a lot of the time, the expenses that the bank is looking for was because the borrowers thrashed the property. They didn't look after it. Repairs had to be done in order to make it saleable and safe for sale. And those are legitimate expenses called protective disbursements that the court will allow. So then that oftentimes drives the borrowers into bankruptcies, and I see them on Friday afternoon, so I can't get rid of them. Or they can't get rid of me, probably, is probably closer to the truth. So regular chambers, half an hour or less, special chambers on 2 times during the week. And sometimes special chambers can start at 11, you break at 12:30 for lunch, come back at 2 and continue it in the afternoon. It can consume two time slots in a day. And I mentioned about the complex ones, that could be a day, 2, or whatever amount of time. And we depend on the estimates from the lawyers as to how much time might be required to hear one of these complex or special chambers matters. All I know is that there's plenty of work. This assignment that I took beginning at the 1st of July was sort of, it's new. One of my colleagues started it at the beginning of April. He did it until the end of June, and I picked it up from there. And I'm finding that it is much more involved, much more time consuming, and quite frankly, much more challenging than I anticipated. And there's not that much variety. Some, but not near as much as if I was in the regular rota, which we'll do in January. I'll go back and I'll be doing, because I know I have a criminal jury trial in Amherst, I've got a divorce matter in Truro, I've got other special chambers weeks scheduled starting at the 1st of January, and I'll stay in that regular rotation till the end of June. And then I'll decide whether or not I want to go back to do this, or maybe we as a court will decide that we don't want to continue with this experiment that we're doing.
So you start court tomorrow at 9:30?
9:30, yeah.
So like in your special chambers is supposed to start at 11?
Yes.
So will you try to finish all of your 21 dockets before you go to that?
Yeah.
Okay, sorry, I just want to clarify.
Yeah, and the 11 o'clock one is a bankruptcy matter. So the Deputy Registrar of Bankruptcy, I've already asked her to contact the lawyers who are involved to tell them, you may have a wait. I'm not saying don't show up, but you may have a wait. If I knew it wasn't going to be contested, that's a different story. I think what I would do then is bring them, the lawyer in at 11, go from the Chambers courtroom down to that courtroom to open court, and just adjourn it until the afternoon. So the lawyer is not there cooling his jets for 2-3 hours or whatever waiting for me. But that's not good, and I'm not pleased that may happen, but it likely will happen as well. Yeah.
Sorry, I just wanted to clarify.
Yeah, no, I appreciate the questions, yeah. In a normal sitting day for a judge, we normally start at 9:30. If we're doing what's called Crown side, criminal chambers work, on every Thursday that happens at the law courts, that starts at 9 o'clock. And I think the reason why we start at 9 o'clock is a lot of the lawyers that are in front of us in Crown side are also doing criminal work in provincial court. And hopefully those people who have, a trial or something scheduled in provincial court, we can deal with them first, send them on their way, so they're not keeping the provincial court judge waiting up in Spring Garden Road as well. Sometimes, again, it's unavoidable, and we just hope that when the lawyer leaves our court and goes up to Spring Garden Road, the judge sitting there will understand the reasons for the delay. And I think most of them will, because we are judges, but we weren't always judges. We went through as lawyers to begin with. Now, when I first started practicing law, I appeared before some judges. Quite frankly, when I left the courtroom, I wondered to myself, what have I ever done to that man, and it was usually a man, to upset him that much that he would give me such a hard time? I don't know if that's the experience that very many people have now. At least I hope not. Because we have to understand that things happen. Sometimes no one's really at fault, and we just have to learn to be patient and understanding. And in my case, I don't ever want to run the risk of upsetting a lawyer, because as a judge, I'm depending on you, the smart lawyer who knows the file, to educate me so that I can make then a better informed decision. It might not always be right, but at least I'm better informed. But I have great respect for the lawyers that show up in my courtroom, and I think most of my colleagues are the same way, because they do good work. They pretty well all come into court well prepared. And if they don't come in well prepared, it becomes painfully obvious, and it gets very awkward it gets awkward certainly for the lawyer who doesn't know the file as well as the judge, but I find it awkward as well, because I don't like seeing someone squirming in front of me like that, to tell you the truth. Anyway, so back to where I left off before with Chambers. So I think I probably beat the Chambers dockets to death. And I did, thanks to your question, segue into criminal chambers, which we call Crown side. And what we do at Crown side, for the most part, it's the first appearance after the accused has gone through the provincial court for the inquiry, the preliminary inquiry. So they come to our court, and if it is, I guess, a matter for a judge and jury, or even if it's a matter for a judge alone, they have not entered a plea yet by the time they get to us. They'll enter a plea if it's a judge alone trial that's being requested. They're arraigned. That's what, when you hear that word arraignment, that's basically when the charge is read to the accused, and the accused is then asked to enter a plea. Sometimes the accused refuses to enter a plea, and at that point in time, the criminal code allows us then to automatically enter a plea of not guilty on behalf of the person. If the person is there, for instance, on a first or second degree murder charge, that's a judge and jury situation. The plea is not entered until they're brought in on the day to select the jury. And after we go through these the preliminary exemptions, general and special exemptions, and we have the panel there, what's left of the panel, at that point in time, the accused is arraigned, because the entire panel is supposed to hear the accused entering the not guilty plea. So it has to wait until that point in time. And I'm not exactly sure, because the procedure that I've adopted, I guess, or was forced on me when I arrived, you're talking about hundreds and hundreds of years of British common law that has evolved to the point where now we've codified it. Britain doesn't have a criminal code the way we do. But a lot of the procedures and whatnot that we've we follow, they came from the British common law system, I guess. We've inherited that. And similarly in the United States, because they were a British colony at one time. Now the U.S., I mean, they've done their own thing since 1776, so they're not identical to us by any stretch, but most of the common law countries, such as Australia, Canada, New Zealand, any of the former British colonies, I mean, criminal procedure, criminal law is quite similar, but not the same. And we do things in Nova Scotia. I mean, obviously we have to comply with procedures that are set out in the criminal code. But sometimes the criminal code doesn't lay out a procedure. It provides a mechanism for someone, I guess, for instance, with a jury trial, there are provisions there that will allow for an accused person to select a jury of 12, 13 or 14. And that supersized jury, what I call it, that was only initiated about probably 8 or so years ago by the former federal government, the Harper government, and it was designed, I guess, more to cater to these long trials, or long trials that involve biker gangs and other type of criminal organizations, because they're finding that these trials were going for such a long period of time. You could lose jurors during the trial for one reason or another. And with a criminal jury trial, you can continue with the trial. If you start with 12, you can lose 2 and be down to 10 and continue with the trial and expect that 10 will give a verdict. But if you go to 9, you have to declare a mistrial, send it back, and start all over again. So if you start with 14, then you've got that cushion of 4. So you can lose 4 during the course of the trial and still continue with the trial. The very first trial in Nova Scotia that was done with 14 jurors, and I think, in retrospect, the very first one that started in the country and ended with more than 12 jurors was one I presided over. It was a murder trial, and we started with 14, and we ended with 14. But the criminal code doesn't provide a mechanism for reducing the jury back down to 12, because only 12 can deliberate and come up with the verdict, which is, quite frankly, when you think of it, very unfair, because 14 people have heard all the evidence, but we have to put all their names back in a box and eliminate 2 of them so that 12 can go back to the jury room. No procedure, nothing recommended, no case law, because as I said, I think there was 2 cases in Ontario that started with 14, but by the time they got to removing the extra jurors, they'd already lost at least 2. So they didn't have to come up with a procedure. So I had to come up with something that I thought would work, and that would prevent, for instance, if you sat there and that trial went between 6 and 7 weeks. If you were there for 6.5 weeks and I pull your name out of the hat, oh well, what do you think? Are you going to be happy with me?
Not exactly.
No. You mean I alerted all of them to this, I guess, reality. If indeed we still had more than 12, I had to remove the excess number to bring it back down to 12. So it wasn't a surprise. I didn't want to do that. But on the morning, and they've heard all of the evidence. They heard the closing arguments of both Crown and Defense Counsel. They heard my charge to the jury. And at that point in time, just before you send the jury back to begin their deliberations, we had to put all those names in a hat, and I told them in advance, I said, if you hear your name, you have to stand up. You have to, if you have any personal belongings with you here in the courtroom, take those with you. You go over and stand by the deputy sheriff here. You can't say anything. You can't talk to any of your fellow jurors. You can't do anything of that. You just have to stand up, take your stuff, and stand here. And so I did that with both of them. I thanked them. I sent them back with the deputy, because those personal things that they had, if they took notes during the course of the trial, that couldn't be left in the jury room, because the other jurors might see that so-and-so has concluded that, the accused is guilty. Well, they can't influence the 12 that remain behind, so we had to make sure that they went back, gathered up all their personal effects, but any notes or any materials, or in this case, we had each one of them had a volume of photographs, and they were, you wouldn't want to take them home with you anyhow. There were some very, very gory pictures of the human remains where they were found in the woods. But those types of things had to be given to the deputy sheriff, and then we took custody of it and made sure they were disposed of properly. But they're like their wallets or purses or whatever, their cell phones and stuff like that, they could take those things home. So anyway, at the end of the day, we succeeded in I guess eliminating, if that's the proper word. It seems kind of harsh, given how much time and effort that those two jurors had put into the trial. But we removed them from the jury proper. And then we sent the jury back to begin deliberations, and after, how long that one went, it was a couple of days, but they came back with a verdict. I've also had trials where, after deliberating for about 3 days, my final note from the jury foreman was, "We don't care how much more time you give us, we are hopelessly deadlocked, and it's pointless to go on." And guess what I have to do at that point in time?
Call this trial?
It's a hung jury. And on that particular occasion, I said to a friend of mine, I said, what really bothered me, because it was down in Pictou, it was a Saturday afternoon, and not only did I have to declare a mistrial because there was a hung jury, but it was too late in the afternoon to get back to play hockey with Ash and my buddies at 4 o'clock, so I missed my hockey game besides. Yeah.
So why is it that you can only have 12 jurors actually decide things, and why is it an even number? Because that doesn't make much sense, because then you do have that the deadlock thing, the hung jury. So how come it's not like an uneven amount of jurors to be able to?
I've heard different theories. I've even heard one theory that there's 12 because Christ had 12 apostles. Again, this goes back to probably Magna Carta days, when the barons and the earls in England were able to try, at least, to extract from, was it King John? I don't know what the king was at the time. I think it was King John. Yeah, some concessions, but one of them was that if someone was charged with an offense, they could have a trial before their peers. Now, where the 12 started and how it started, I don't know. But over time, it's evolved to the point where you can have 14 during the trial, but again, they didn't change the criminal code. This is the former Harper government, to allow for more than 12 to deliberate. Still has to be no more than 12, but as I mentioned before, it could be 11 or it could be 10. Can't get below 10. And that's, again, a case for a mistrial.
And in terms of the number, like even or odd, you need a unanimous decision from the jury. It's not just majority. So it doesn't really matter if it's even or odd, it has to be unanimous. I'm right on that, right?
Yeah, it's got to be unanimous. Yeah. Yeah, because I had another situation which was an interesting one. Someone was charged with possession for the purpose of trafficking. And so an included offense in that charge is simple possession. So the jury was deliberating, and one of the notes that came from the jury foreman was that, I forget exactly how it was. I think so many of them wanted a conviction on possession for the purpose of trafficking, which is the more serious one. And some didn't, a few didn't. They actually gave me numbers. But so when I shared that, which I have to with the prosecution and defense counsel, the prosecutor says, well, I guess then we have a conviction on simple possession. And I said, do you think so? And he said, yeah. I said, well, they're all in agreement that there was possession, because those that felt that there was possession for the purpose of trafficking had to conclude first that there was possession. The other ones that weren't convinced beyond a reasonable doubt that it was for that purpose of trafficking, they were convinced that yes, simple possession, nothing more. And I said, that's not unanimous. You know, you can't just say, okay, come in and we'll convict you on possession, because it's not unanimous. The same as if the jury decides to acquit, they all have to agree that an acquittal is the proper verdict. If 10 feel that an acquittal is appropriate and 2 no, 2 want a conviction, well, that's not unanimous. So again, you've got a situation where if the deadlock, you know, if they can't all get together and agree on one verdict or another, then I have to declare a mistrial and send it back for a new trial.
Okay, so mistrial just goes back to a new trial. It's not just like the person can walk away from it all?
No. But it's like any prosecution. It's kind of like I've had one where a gentleman was convicted by the jury, and it went to the Court of Appeal, and the Court of Appeal overturned the conviction, saying that when I charged on self-defense, I charged on this provision, which was right, but there was another provision dealing with self-defense that I didn't charge on, and I should have, and that could have made a difference. But by then, the guy who had been wrongfully convicted had served his sentence. So the Court of Appeal said, wink wink to the prosecution, you might want to give this one some thought, and they decided not to go ahead with it.
Yeah.
For obvious reasons. I mean, he already served his sentence.
That's something else I wanted to bring up, particularly the Donald Marshall case.
Yes.
Yeah. So for wrongful convictions, and that's one in Nova Scotia, what kind of like punitive measures are taken? Because like as a judge, it's not really, at that point, especially in the Donald Marshall case, I felt like most of the issues were police coercion and like a lot of police misconduct. What kind of punitive measures are taken in like justice-seeking methods do you guys take to? Well,
in that case, I guess, in terms of Donald Marshall Jr., he received some compensation, at least for the time that he spent in jail when he should not have been there.
Yeah.
It's really not compensation, isn't it? Sort of like somebody that's involved in a car accident and they're banged up, they may be disabled. I mean, you can give them all the money in the world. It's not. They just want to they want to go back to the way they were before the accident. You can't. But at least that's the only way, I guess, that we've come up with that can provide some degree of compensation for a wrong that's been done. In terms of the prosecution and the defense, because there was a public inquiry arising out of the Donald Marshall matter, and I'm not sure if you recall, because the Nova Scotia Court of Appeal made this decision before you were born, probably, but there was a comment by one of the judges saying that the harm was more apparent than real, or something like that, or basically they blamed Donald Marshall, even though you're wrongfully convicted. Well, you've done enough bad things in your life, you've got to deserve what you got, type of thing. Those judges who were involved from the Court of Appeal, there was a complaint made against them, and they had to go before a disciplinary committee of the Canadian Judicial Council. They weren't, none of them were forced to be removed from the bench or anything, but at least they were held accountable for a rather unfortunate choice of words. He was not guilty. He was wrongfully convicted, and to say afterwards, well, there's no real harm, no foul here, because you probably deserved something anyhow. That's not the way the system is supposed to work. So, as a matter of fact, when you're talking about Donald Marshall, about 3 weeks ago, I was up at the law school, and there was an unveiling of a portrait of Donald Marshall Jr., who I knew personally, not well, but when I practiced law in Sydney, I got to know him and went to the same church that he went to, and knew a number of members of his family and whatnot. His father was the Grand Chief, Donald Marshall Sr., and a finer gentleman you could not meet. And Donald, surprisingly enough, I mean, he given what he had gone through, he came out remarkably strong, but he did have to grapple with a lot of things that you and I would not have to deal with. And I mean, I think there was inherent racism at the core of that as well. He was expendable. He was an Aboriginal person, which is not the way justice is supposed to. You see the scales of justice. Well, Lady Liberty, she's blindfolded, right? But unfortunately, I think there's being improvements being made in society generally, but I fear, even with myself, maybe I have racist tendencies and I don't even realize I have them, type of thing. I don't know. I hope I don't, but sometimes one never knows. It may be subconscious. Anyway, there are improvements, but there's still a long way to go to make sure that everybody that comes to court, no matter what they're charged with or what brings them to court, they are treated with respect and the dignity that they deserve.
I'm sorry to ask so many questions. I have another one.
Not at all.
Do you ever feel like pressure in like one of these like extremely like gruesome or like really big cases to like just kind of push the court forward regardless of like the evidence that's been presented? Like, do you ever feel that kind of pressure? Like, you want, like, people obviously want these things to be solved and dealt with very quickly because they don't like, I don't like the idea of having someone who's like raped a bunch of people and murdered a bunch of people just running around my city. Do you ever feel that kind of pressure and like?
Well, I'm not sure. There's a lot at stake. There's a lot of different dynamics going on in the courtroom, and particularly in cases where there's a deceased victim. You know, there are two sides here. There are people supporting the accused person, and there are people, family members of the victim, type of thing. And I find that those kind of situations, they can get quite volatile. I try, because in the murder cases that I've dealt with, like during the course of the trial, I'll just remind people why we're here, you know, and that I know it can be very emotional and it can be very traumatic at times, but we have to try to maintain decorum. Because as a judge, I have to ensure that the accused gets a fair trial. And we can never lose sight of the fact that an accused person in this country, under the Charter of Rights and Freedoms and as a basic tenet of criminal law, you're presumed to be innocent. You can be charged, but you're presumed to be innocent. Now, not everybody buys into that, especially if it's an allegation of abuse against a child or an allegation of, let's say, sexual assault against a child. You get accused of that, you may be presumed innocent under the Charter, but there are people that, you know, they've concluded that you've done the dastardly deed and you should be punished severely for it. So the role I take there as a judge, my first and foremost concern is to ensure that the accused gets a fair trial, because he or she is presumed innocent. As far as I'm concerned, they are innocent, and it's only at the time that the Crown has advanced sufficient evidence to prove beyond a reasonable doubt each element of the offense, that's when that presumption is extinguished. Or if the accused party decides that they're going to admit to the elements of the offense. They're going to plead guilty, change their plea or what have you. That's a different story too. But for the most part, those cases that I've dealt with where there has been the potential for an emotional type of reaction, I'm just amazed at how people control themselves. And that morning or that time of day when you know the jury has reached the verdict, okay, everybody is asked to come back into the courtroom, and before the jury is brought in, I will once again say, look, you know, we are at the point now where the jury is going to be asked to come in and render its verdict. You have to be prepared for it as best you can. Please try not to lose control of your emotions. I don't want to have any demonstrations in the courtroom. Listen to what the jury has to say. They deserve the respect now that they have heard all the evidence and they've deliberated, you don't want to say or do something, it's difficult enough for them. And like the cases I presided over, it's amazing how controlled people can be when called upon. And I usually try to make sure that they know that I respect and maybe not sympathize or empathize. I can't. I mean, I'm not directly involved with the impact of this crime, but I try to make sure that they know how much I respect them for the way they've conducted themselves. And the other thing is, I have to be very conscious of, sometimes people will be there in the courtroom trying to intimidate witnesses. I can't see everything. I mean, I try to be alert to what's going on, and if I have a jury, I have to be aware of them. I have to make sure that I'm hearing the evidence, because I have to charge the jury and provide them with a summary of the evidence that I think is relevant. I'm conscious of the lawyers that are in front of me. I'm conscious of the accused. It's hard to sort of keep track of everyone and everything that's going on in the courtroom. But if I spot someone who is sitting in a way where they have direct eye contact with a key witness, and I sense that there's an effort going on to intimidate the witness, I will then take a recess. I'll talk with the deputy sheriff, and if necessary, I'll remove the person from the courtroom if I feel that there's an overt attempt to try to intimidate.
Three things. There's a question here. We have about 5 minutes left. And just on the point about pressure to speed things through, I would argue that kind of pressure to get the bad guy and shortcut due process is what led to Donald Marshall.
Yeah, exactly.
Right? So yeah, the moral pressure might be there, but it's a dangerous pressure.
Yeah.
Right? So, sorry, go ahead.
I just have a question back about jury, because I know you said something about how you mentioned there was like a stack of like really gruesome photos. Like, what kind of happens in the sense if someone who's like selected for jury can't handle it? Because you said the thing about the photos, and I instantly was like, I couldn't look at a bunch of bloody photos without feeling like I need to leave or be sick. Like, will somebody be removed, or like what kind of happens in that sense if it's
possibly
too much for someone to handle?
you try to, and that's not something you can deal with before the jury is selected either. In the one particular case, that gruesome murder trial that I presided over, there's a couple of stories arising out of that, but I knew what the photographs were going to be, because I had discussed it with the lawyers beforehand. They had discussed it. They agreed, okay, of all the photographs, here are the ones that are going to be put in the booklet and presented as an exhibit to the jury. They already agreed upon them. And some of them, like they were autopsy pictures, and one of them, I mean, it was, I hope I don't make anyone upset here, but the pathologist, in order to explain or demonstrate the trajectory of the bullet after it entered the person's, from where it entered the person's head behind his ear, they had a picture, but with a little green, like a tube sticking right through, like a, But I tell the members of the jury that, when this booklet of pictures or photographs were going to be presented to them, I told them, now you have to look at the evidence. You have to listen to witnesses, you have to listen to questions, you have to listen to answers, but when the Crown or defense enter as exhibits such things as photographs, that is evidence. You have to look at it. And I'll caution you that some of these pictures you will find rather upsetting or unsettling, whatever it was. But I have to insist, if you do look at them and if you need time, we'll recess. But if someone is so traumatized by them, then that may be an instance where that particular juror has to be excused. Yeah, so we could do that. But the other interesting sort of anecdote about that particular one, I worked on that case day in, day out for almost 7 weeks, to the point where at the end of the day, I'd go home, I'd be exhausted. I'd go to bed at 11 o'clock, 2 hours later, wide awake. Could never get back, so I go back to my office. And it seemed like whenever I was reviewing and, I have to summarize evidence, if I wanted to look at something in that exhibit book, every time I opened it, it was to the picture of the victim face on where they found him under a fallen down tree. So I finally got to the point where I took a yellow sticky and marked it, so I wouldn't open it up to that point in time. Because it seemed like every time I opened the damn book, I was looking at this guy, and gee, it was... So by the time that was over, I was... but it's funny, because it didn't stay with me. Because I went right on to something else, and then you kind of, once in a while, I'm reminded of it, but you don't dwell on it. So hopefully I'm not getting PTSD after all these years.
Well, that was going to be my question. How does all of this accumulatively affect you as a judge sitting there and having to go through all of this evidence from not just one case where juries are sitting on, but several cases?
Yeah. Well, like I said, I think the good thing is that you do move on to something else. And I guess what's available to me is the same as what's available to jurors who are impacted by some of the evidence that they've heard or seen. There are counselors, and we provide free of charge therapy or counseling or whatever to these people who feel that they do need, I don't know, you've seen me hit with the puck, and I've never cried or anything, so I must be tougher than I think. I don't know. Yeah. Anyway, it hasn't had that kind of effect. The cases that really impact me criminally are the ones that involved abuse of children. Yeah.
All right, we have time for maybe one more question.
Last chance. Remember, I'm a judge, not a lawyer. I can't send a bill to you. Anyway, we've scratched the surface, and I know I bounced all over the place. But the bottom line is, I guess the justice system that we enjoy and that we're privileged of having here in Canada, I mean, it covers everything from soup to nuts. You got small claims court, you got provincial family and criminal courts. Superior criminal and family and civil matters are all dealt with, and the Court of Appeal. Again, anything that comes out of our court that is to be appealed goes to the Nova Scotia Court of Appeal. And sometimes that can be a little daunting, knowing that my work product is being looked at by three individuals who are much more intelligent than I am. But I've got to the point where I look upon the Court of Appeal as, again, they're there to help me. They're there to educate me. They're there to correct any mistakes I may have made so that there is not another miscarriage of justice such as the one that impacted or affected Donald Marshall so significantly. But even members of the Court of Appeal in Nova Scotia aren't always right. That's why there's a Supreme Court of Canada. That's the ultimate court in the country, and all provinces, all territories that have superior courts or courts of appeal, their rulings go to the Supreme Court of Canada. Not as of right. Some are as of right, but the Supreme Court of Canada, you have to make an application for leave to appeal, and if granted, they'll deal with the appeal. But you have 9 members of the Supreme Court of Canada, and sometimes 5 will agree on an outcome, and 4 thinks there should be another outcome. And then when you look at the decision, the 5 that agree on this outcome, 3 think it's the right outcome because of this reasoning, 2 say this is the right outcome but for this reasoning, and then the 4 who are in dissent all agree why it should not result in this. And sometimes it's the dissenting judgment or opinion that's much more easy to understand. Bottom line is, the law is not black and white. It's gray. And I guess it's probably a good thing that it is. There's ways of presenting things, there's ways of arguing things, and there's no such thing, I don't think, as right and wrong. Decisions have to be made, results have to be arrived at, and the people that make those decisions, I think, all the people I know anyhow, myself included, we make decisions that we think are right based on what we understand the facts of the case to be and what we understand that the law of the land is as well. But I've been overturned on appeal on a number of occasions, so despite my best efforts, I can make mistakes. We all can. So no other questions?
All right. Thank you very much.
Yeah.